liberty interests require me as an employer to accept less work productivity, or me as a taxpayer to accept increased social costs that cost government agencies of all description, of all levels, more money? Do we measure liberty only by intemperance and excess? That's something we ought to consider, along with what liberty interests are. You know, in 1982, a young schoolgirl in the city of Oakland, California, had a visit by the First Lady of America, Nancy Reagan. It was in her classroom. In a very televised way, this young lady, who was a minority, said to the First Lady, who was very far removed from this young girl's life, and said, "First Lady, or Mrs. Reagan, what do I do if a drug pusher approaches me out in the schoolyard or on my way home?" And Nancy Reagan gave a 3-word response. She said, "Just say no." And what happened? America mocked her. She endured merciless mocking for that advice. And I have to admit, probably in 1982, 1983, and 1984, I probably thought she was worthy of mocking as well for that comment. But she turned it into a program, the Just Say No program, that really did have an impact on drug use during the 80s. And in fact, through its course of moral suasion and peer pressure, it had a practical impact. Earlier I mentioned 1978, that 50.1% of all high school seniors would admit to the University of Michigan. Admit. You know, 50.1 were admitting, there was a heck of a lot more who were doing. So in 50.1% in 1978, during the course of the 80s, there were huge precipitous drops, according to the Institute of Social Research, such that by 1991, that 50.1% was all the way down to 12% of high school seniors admitting to the use of marijuana. Is that bad? You know, while I was preparing this speech, went to a library, but also on the internet, trying to look at some source material to try and help me think about and consider the issues I should address or mention in the keynote. And one thing I found was when I did a Google search, I found a cached DE web page. It was cached, and it appeared from the documents and to be from 2004, 2005, so I started reading it. And the page was dedicated to rebutting in a common argument that if marijuana or other drugs were decriminalized, that the social costs would go down, that the billions we spend at the federal level and local level would go down. And that a lot of social costs, such as violence in urban settings and cities, in suburban settings, would go down, and that there overall would be less costs. So the DE website argued, not completely unconvincingly. They had some merit in this argument, and this blurb was, in essence, this: that the cost would most certainly be higher without the DEA's enforcement, or without law enforcement's enforcement. Because right now there is only 5% of Americans, according to the DEA, use illegal drugs. Again, a number that's probably too low. But nonetheless, let's accept that. And they said the flip side of that is because in part of enforcement, 95% don't. And because those 95% don't, the social costs are lower than they would be otherwise. And I have to admit, that does have some weight, that cannot be dismissed. Because I think we all know peers, or ourselves, who do look to the law. It does matter to you, or many of our peers, or friends, or family relatives, that whether something is legal or illegal, and whether we're going to decide to engage in it. If for no other reason, it changes the risk-benefit equation. But then this website went on to tell me that if cocaine were legalized, cocaine use would go up tenfold. And that's where they lost me. Because again, as we get proponents on both sides are wont to do, they take a kernel of truth and try and extrapolate that into everything that they want to believe. And again, that underscores, I believe, why this symposium is so important. Okay, a little more bashing on my side of the aisle, the conservative side of the aisle. William F. Buckley, okay, the line of American conservatism, the guy who pulled conservatives out of the wilderness in the 1950s. Well, what did he write about the DEA sort of thinking? In a number of columns before he died, he wrote frequently on the topic of legalization. But I want to pull something he wrote in the National Review in 2004. He said this, quote, "Conservatives pride themselves on resisting change, which is as it should be. But intelligent deference to tradition and stability can evolve into intellectual sloth and moral fanaticism. As when conservatives simply decline to look up from dogma because the effort to raise their heads and reconsider is too great. The drug laws are not exactly indefensible, because practically nothing is. And the thunderers who tell us to stay the course can always find one man or woman who, having taken marijuana, moved on to some severe mental disorder." And he's right. But then he went on. He finished the argument with this. Quote, and again, he finished in a way that only William F. Buckley could. He said, quote, "But that argument is on the order of saying that every rapist began by masturbating." And really the point is, you can take one criminal fact and take it to its logical extreme and really present a false argument. And I think that's the point he was making. He then went on to make an observation in the same article from the National Review in 2004 that really applied to me and my friends. As we were in high school listening to Peter Frampton, Led Zeppelin, and Jimi Hendrix. And it was this, quote, "An estimated 100 million American adults have smoked marijuana at least once, the great majority abandoning its use after a few highs. In fact, by my count, at least three of our last three presidents have all admitted to smoking marijuana. At least two of them admitted to inhaling. Yet all three gave it up. All three gave it up. So much for being the gateway drug. During my 8 years as Attorney General, the people of the state of Michigan initiated 4 different referenda. Sorry, it's early in the morning. I'm a little dry mouth from having a cold earlier. Initiated 4 different referenda to change our state constitution. Oh, thank you. And these 4 referenda dealt with the following topics: racial preferences, civil unions, embryonic stem cell research, and of course, in 2008, medical marijuana. And I have to tell you the truth. I found the medical marijuana referendum, the whole issue, really much to do about nothing. In my mind, unlike what I thought were much bigger issues dealing with racial preferences, embryonic stem cell research, civil unions, which for me really dealt with the individual autonomy, and the role of society and self-government, and the interplay between civil rights and the social compact. Those 3 all dealt with that. For me, medical marijuana was really kind of a sideshow. And I thought of it in a very personal way. My almost 84-year-old dad was dying of cancer, had some chronic disease. He and my mom could figure out how to get some marijuana, if that's what would help him eat, without having to get a prescription. And I expect most 80-year-olds could, from family members or friends. The other side of that, there were so many proponents on the other side saying that medical marijuana would be the end of the world and it was a horrible gateway drug. And from my own experience, I knew that wasn't true. So I was largely indifferent. I tried to pay attention. I was the Attorney General of the state of Michigan, and this was going to be something that was going to change our Constitution. I should care about that, but it was very hard for me to really get worked up about it. And so I didn't. And I voted against it, and I voted against it because I thought the issue was too small to amend our Constitution. I don't think we should just be amending the state Constitution over sideshow issues, as I thought of it at that time. And you know what? In spite of my personal indifference, but maybe because they shared my indifference, 63% of Michigan citizens voted for it. It won overwhelmingly, 63 to 37, to provide for the use of medical marijuana as an exemption or exception to the state law prohibition against marijuana for those who met the criteria of the amendment. During my last 2 years after it came into being, I was still kind of indifferent. During my last 2 years as Attorney General, after the passage of the amendment in 2008, I still thought there was a lot bigger issues to care about. For one, the economic implosion of our state. And so here's what I told my assistants. I said, our client is the Department of Community Health. They work for Jennifer Granholm. They're the regulator. We're going to assist them as long as they try to adhere to the spirit and the wording of the law, of the amendment. But we're, like we would do sometimes on other issues, we're not going to have an agenda. This is really up to the Department of Community Health, a purely technician sort of perspective. Help them in executing the appropriate administrative rules to implement it. Nothing more, nothing less. Don't fight them, and don't push an agenda. Some in law enforcement thought I should rattle the sword. Hey, I had been the homicide prosecutor in Detroit. I led all the homicide prosecutions in Detroit before I was elected as Attorney General. I'd been a career prosecutor. I'd got my plaque as a 20-year prosecutor. Why am I not going after this? Why am I not fighting anymore? The flip side of that, others who were advocates, a couple of them are in the hall today, were pushing me and saying, why aren't you doing more? You know, it's a constitutional amendment. You're supposed to push it more. But I couldn't really get beyond my indifference. It didn't pass what I called the grocery store test. You know, when I'm at my local Bush's and someone comes up and would harangue me about an issue, that met the grocery store test. No one ever came up to me in Bush's or Spartan or wherever I shopped and ever complained about, why aren't you doing more to implement it? So I kind of left it alone. But there was an issue that came up during my last year that started me to think about it a little bit more. And as this issue has made its way up to the United States Supreme Court, it's made me start to think about it more and more. You know, on March 23rd of 2010, the President of the United States signed into law perhaps one of the biggest pieces of social legislation, certainly, I'd say certainly since the New Deal. President Obama signed the Patient Protection and Affordable Care Act, commonly called Obamacare, into law. And within 30 minutes of that, I and 6 other state attorney generals filed suit in the Northern District of Florida in federal court. And why did we do that? We did that because we viewed that act as containing a fundamental attack on liberty here in America. That the individual mandate was an impermissible exercise of the Commerce Clause. Our legal argument was based on the plain text of the Constitution, plain text of the Commerce Clause, plain understanding of what the founders thought it meant, but also recent Supreme Court cases. United States versus Lopez, where the Supreme Court said, overturned a federal law for charging gun possession with 1,000 feet of a school in Texas. And United States versus Morrison, which some of you may recall, as that was the case that overturned the violence, pieces of the Federal Violence Against Women Act. And so we thought, hey, we had a Supreme Court that was slapping back an imperial Congress. It had a true understanding of the liberty interest and also an idea of state sovereignty. And we argued, and we still do, that the Affordable Care Act, dragging someone into a marketplace to regulate them and fine them if they don't buy something, is an attack on the liberty interests of normal Americans, of regular citizens. But there was a curious and disturbing case of Gonzalez versus Raich, decided in 2004, where the Supreme Court had the opportunity to address the breadth of the Commerce Clause and congressional power in the context of what? California's Proposition 215, passed in 1996, the first medical marijuana law, I believe, in America. Under Proposition 215, this simple, sick, vulnerable lady, Angel Raish, took advantage of Proposition 215. She had an inoperable brain tumor in her head that led her to have constant pain. And that constant pain led to a medical condition commonly called wasting, where she couldn't eat and she was losing weight, and it was putting her at risk of dying. If any of you have had any friends or relatives undergoing chemo, you see a similar thing happening. And it's not necessarily the cancer that kills them, but it's the treatment for the cancer that kills them over time. And so her doctor prescribed her medical marijuana. Under 215, you can't sell or deliver medical marijuana to someone else. And so by the very terms of the state law, she couldn't give it to anyone. And she was only growing it for personal use. So think about that in the context of our current debate over Obamacare. Really very the same thing. She's not engaging in any market, not even engaging in a local market, let alone an interstate market. How could the Commerce Clause ever apply to her, especially where she had a state constitutional granted right? How could it ever apply to her? Well, one would ask that, but Justice Stevens would answer how it did. And I won't read for you the opinion because I want to get the questions and answers. But here's, in essence, what he wrote for the majority is that Congress has a power to regulate local activities, so it's not under Section 8 of Article 3. You don't see that anywhere there. Local activities that are part of a, quote, economic class of activities. They have a substantial effect on interstate commerce. And he relied on the Wicker case from the New Deal. You know, that for those of you in law school, that's the case where the farmer, the poor, I think he's in Minnesota. He can grow 11 acres of wheat, and he grows 6 more, and the 6 more acres are for his own consumption. And there, as part of the New Deal, court said, well, that personal consumption impacted interstate commerce because, well, if he didn't consume his own wheat grown in his own property, then he'd be forced to go out and buy it somewhere else and locally, and that might impact the interstate market and, of course, the agriculture subsidies. In essence, Stevens relied on Wickard and one other thought. He said that unlike Lopez and violence against women, that the Controlled Substance Act, Nixon's war on drugs, was comprehensive. And it was well thought out, and it was big. In essence, his test was if Congress passes a statutory structure that's really big, then it's constitutional. But if it's small, like targeting guns in a school zone, then it's not. So think about that. And Justice O'Connor got that. Basically, what Justice Stevens and his 5 other colleagues, including Justice Scalia, were saying, if you really overreach, it's not a violation of liberty. But if you don't reach a lot, then it might be. In fact, I love Justice O'Connor. If you read her opinion, she said stingingly, bitterly, quote, allowing Congress to set the terms of constitutional debate in this way, by packaging a regulation in terms of local activity in a broader scheme, is tantamount to removing the meaningful limits on the Commerce Clause. And she also saw it as an attack on that Brandeis dictum we all learned in high school civics, you know, that the states are the laboratories of democracy. And she bemoaned that attack as well. Justice Thomas, who I know unfortunately isn't nearly as respected or beloved as Justice O'Connor, but I did like his opinion too. He said that now Congress and the federal government could regulate quilting bees, clothing drives, and potlucks, and warned that if Congress can override a state's license of medical marijuana, then, quote, they can regulate virtually everything, anything, and the federal government is no longer one of limited enumerated powers. And when I read that, I hear my arguments against Obamacare. You know, over the past years, the various circuits have decided the Affordable Care Act as it's winding its way through. I've been reminded of that with each decision. And I have to tell you, when it was written in 2005, the Raich opinion, I didn't really care. I was a reflexive prosecutor. I didn't really see, in the end, what could happen with the passage of time. And with the passage of time, the merit of O'Connor and Thomas's arguments have become much more self-evident. Why? Because if federal agents can seize the property of Miss Raich, property that was never going to make its way into a market, let alone an interstate market, in direct contravention of a state-granted right, constitutional right, and in an area, police or local crime, which has traditionally been a state's issue, in an area that's always been a state issue, then what is off limits for federal power? And with time and reflection, I came to see that medical marijuana is a much more important issue than I ever thought of, and that there are true liberty interests in it. And whether you're a conservative or a liberal, or whether you vote for Obama or Gingrich or Romney, you ought to care about it and think about it. And I expect that the issues here today will and should challenge us. I know that many people are offended that many of the advocates of medicinal marijuana are really using it as a Trojan horse for full legalization. And it is perhaps disingenuous and offensive. But for me, that doesn't mean we shouldn't examine what the people did in 2008, or we shouldn't ignore what the people did in 2008. Because is it more offensive that, or what is more offensive than a federal government that would trample state sovereignty underfoot? Are the advocates' tactics more offensive than a government at any level that would trample constitutionally guaranteed rights either given by our state constitution or United States Constitution? Think about it. Should this week's decision in United States versus Jones, with the GPS being attached for long-term surveillance, shouldn't that remind us that when we're talking about the war on drugs, that we have to be careful about what that means for our civil rights, especially with the increased use of technology? You know, at the same time, as I mentioned earlier, our personal indulgences, the ability to get high and drunk, is that a liberty interest that should be protected? Flip side of that, have too many of us, regardless of what side of the aisle we're on, or what we feel about marijuana or medicinal marijuana, have too many of us fallen into the trap that William Buckley warned conservatives of, but it's just the admonition that equally applies to everyone? Are we fallen into a position where we're not carefully considering and we're engaging in intellectual sloth and moral fanaticism based on our pre-existing biases, prejudice, and thoughts? All that is a long way of saying this. We're not going to answer all those questions today. But I'm confident, because of the good work of the panel here and your willingness to be here, that we will inch closer. We won't run, we won't walk, but we will inch closer to answering some of those questions in the best tradition of academia and honest debate. So again, it's my hope that we get a little honest talk here. And thank you very, very much for having me here today. Okay. I think hopefully I didn't browbeat you to death too much. Jessica mentioned that if there were time, if people wanted to, we'd have questions and answers. So I'd open it up to the floor if anyone has a question. Yes, sir.
Bill Schuette, as you probably well know, has indicated on numerous occasions that he's on this medical marijuana issue like a laser beam. Then recently, I heard a news report that he is proposing to take the entire budget surplus of Michigan for this year and next budget year and expend it entirely on putting more police officers in the Michigan departments to prevent violent crime problems.
Right.
On whether it would be more prudent to stop attacking and using our drug squads, these paramilitary forces of dispensaries and caregivers' homes that might have one or two extra plants than the law provides, and put those resources that he wants to bring on board, and instead redirect that energy from those drug squads to prevent that violent crime that he's trying to get prevented with these new laws.
Okay, thank you. A couple things. One, I don't want to personalize this, and I always liked the two former President Bushes because they would never critique their successors, and I don't want to do that. So let me depersonalize and talk about issues in a more abstract way. I think, given now that I don't know how many cases we've had in front of the Court of Appeals on this issue, I issued one Attorney General opinion on whether the Department of Community Health could get outside vendors to vet people and do the licensing and registration. I think there's been at least 3 or 4 since that, and just in the past year. I think it would be a lot more productive for the legislature to address the issue and make clear what the rules are. Clearly, I hear some people in law enforcement argue against pot shops, but then they're against dispensaries. Well, the people said that if I'm eligible for medicinal marijuana, that I should have access to it. I would like to see the legislature pass a law that clarifies and makes for dispensaries, so we don't have to fight. So it doesn't become, whether someone's dog kennel was securely locked and has to defend themselves in the Supreme Court, and we can just take it out of there. See, under federal law, we can't just give it to pharmacies because then they could lose their DEA license. But, I mean, the legislator ought to be able to come up with an easy way. Look, we regulate beer distributors. So, I wouldn't mind you make every wholesale beer distributor have a dispensary as part of their ticket to distribute beer and wine and deal with it that way. I mean, I think, in fact, I just talked yesterday with John Walsh, who's head of the House Judiciary Committee, and he was diligently trying to address the main issues, which is dispensaries, a registry. I know some people worry that a registry makes you a target of police, but for a lot of people who are in law enforcement, and we'll use the example of the guy in Owasso who rightfully had medical marijuana, but the police came in because it was open and exposed. If we cleared up, for a lot of police, I think police get a really bad rap here. Regular cops, they're not looking to bust regular citizens. They just want to know what the rules are. And so let's clarify, if we're going to have a registry and what it's used for. If it can be used, if there's a complaint that, hey, I believe my next door neighbor's growing illicit drugs, and the police can check the registry, they say no, the person has a right to do that. They have a medical marijuana license. That's a debate we ought to have. So dispensaries, a registry, and really making it easier to effectuate, most importantly, the will of the people, those people who went to the polls in 2008. In terms of use of police, I think oftentimes if you don't live in a drug-ravaged neighborhood, heck, go down Willis, 2 more miles east or west of here, or east, because or Palmer, and you're going to see people living in neighborhoods that are ravaged by drugs. And in the short run, to tell them legalization is the answer isn't much of an answer, because they have people loitering in front of their houses and their kids can't play in the afternoon. So it's my hope that we start, I like to drink alcohol, but I recognize there's dangers. And if advocates of marijuana legalization ought to recognize some of the dangers there, and that ought to be part of the discussion. I'm wandering a little bit from your question. So my question is, we ought to get a little more regulation to provide more clarity for users and police officers. And then, instead of browbeating and trying to make ordinary citizens into criminals, we ought to be allowing ordinary citizens a way to avoid being a criminal. Yes, sir. I'll try and sharpen those up. That was a little too long, but.
There's recently been a study released that stated states adopting medical marijuana laws have experienced a 9% reduction in traffic fatalities. Considering that there's a disproportionate amount of those traffic fatalities amongst the children 16 to 21 years of age, wouldn't you then say that adopting medical marijuana laws actually saves children's lives and is no longer a danger to children, and therefore we should be framing the argument in those respects?
No, I wouldn't say that. Look, I don't know what you're relying on, and studies can be manipulated any way you want. But if advocates of marijuana could explain to me how a police officer could test someone for marijuana like they can test someone from alcohol, and it's not TH residue from 2 days ago as opposed to 2 hours ago, you go a long way to convincing me that I was an administrator. When I ran the homicide unit, we had to address real problems. And when I ran the AG's office, we had to address real problems. By that I mean there's sort of the macro big issue, and then there's how you administer it. And if we had legalized marijuana today, how would a police officer test someone who was smoking weed and know how impaired they were? I don't know how that works. And maybe there's a way to do that. I'm not aware of it, but I think it would go a long way toward making ordinary citizens a little more comfortable with it if you, in fact, could test and regulate like alcohol. And I'm not aware that the technology exists right now. Yes, sir.
The study that gentleman just cited also indicated that there are more traffic fatalities from prescription drugs than from alcohol.
Right.
Your argument that you can test for alcohol use doesn't apply to the broader problem that is linked to prescription drugs. No methodologies of testing that on the spot either. So my question is, if you are inebriated or you are under the influence of a substance, alcohol, marijuana, or a prescription drug, what difference does it make to the safety of the public as to law enforcement?
Well, let me pull back from the premise of your question, because I'm a lawyer, so I don't have to accept your premise, and I'll take your question and change it around to answer what I want to answer. No, okay. Okay. A couple things. Part of your premise is that it's a prescription drug, i.e. someone started off with a prescription. They had Vicodin because they tore their ACL, or they had spinal fusion, so they have some other painkiller. So at least you start with the premise of, and you can test, you can do a blood test, which they do all the time for alcohol. And you're right, maybe you can't determine the level of Vicodin. Actually, you can determine the level of Vicodin. You cannot for marijuana, at least from my times as a county prosecutor. They may have changed over the years. But when you say prescription, we start with the premise that someone had a medical malady and then they got a prescription for a very strong controlled substance. Put aside medical marijuana. If we're talking about open access to marijuana, legalizing marijuana, and anyone can have marijuana, that's different than someone who's had a prescription for a controlled substance.
Well, if I can read.
You don't get a follow-up after that, because I want to get this. Yes, in the back.
Policy has supported also, but not the determination of the levels in blood or other bodily substances. It's the interpretation of those levels. And marijuana particularly has some unique challenges with that. And so the DRE approach is really a behavioral-based approach, accurate in numerous ways.
Yeah, and you might be right, I don't know. I hang out with a lot of cops, and I sometimes have that gateway drug, alcohol, with cops. And for them, it's a much more practical thing. And you talk with most cops, they see a lot more of the ravages of alcohol than they do of The reality is most people don't smoke weed and beat their wife or their husband. But that being said, you can't just say legalize it and let's all sing Kumbaya. There's a lot of practical problems related to that, and we shouldn't ignore those. And one we shouldn't ignore is, I had this 8th grade teacher, Mr. Marchesati, and I'll call it the Mr. Marchesati rule. And okay, so it was back in 1976. And he said, look, there's enough fools out there drinking alcohol already and can't handle it. Do we want to expand the world of fools out there? And, you know, as an intellectual matter, you know, I can't rationalize that completely, but it makes some sense to me. So my point is, you know, I don't know, I'll say what Sandra Day O'Connor said in her opinion. She said, if I were a legislator, I wouldn't have voted to put medical marijuana on the ballot. If I were a voter, I wouldn't have voted for it. But if it's passed by the people, I will respect it. So my position, quite simply, is this. I don't dispute what you're saying in the studies and everything else. It's not legal right now. I probably wouldn't vote to legalize it. But if I were to ever vote to legalize it, I'd be a lot more comfortable voting for it if a lot of the technical issues were worked out. Practical issues. Yes, sir. Okay. Professor Hall.
Really appreciate your kind of what role did you see?
It had a role. When I, you know, in the 80s, early 80s, you know, crack cocaine and cocaine was a big driver, the late 80s into the 90s. As you got toward the end of the 90s, because of crack cocaine and sort of the focus on that, marijuana became a drug of choice, and so you'd find more drug shootings over marijuana than you had 5 years before that. And you know, it's driven by the market incentive, and so it goes up and down. You know, I've been out of it for a decade, at least at the street level. You know, I expect heroin in the market level of heroin that probably drives more shootings than marijuana did in the late 90s. That was the last one, or oh. He's giving me the hook. He's the boss, so he's got to keep everything on time. Thank you.
Thank you, Mr. Cox, for that. Right now, we'll take a quick break. There's refreshments out in the atrium for about 15 minutes, and then we will reconvene back in here for our first panel. Thanks. Yes.
Testing.
I think she already loaded his, because he emailed it to me in advance, and I sent
Okay.
it to
Oh,
Jessica.
it's right here. Perfect.
Yeah, we got Neil, you got Kevin, his first and second.
Perfect.
Matt, I don't think, I'll
Matt's
see if
in-
Matt and.
Matt Abel?
Yeah.
He's not here yet.
No,
Okay.
neither is William Burtis.
Or Bill's here.
Oh, he
And
is?
I've got his right here.
Oh, okay.
And here's Mr. Goshray's and
Cool, get those all.
Jesse Vivian.
Very fair. He was very fair. Yeah, he was great.
That was one of the, that was like kind of one of the more insightful and genuine talks that I've heard in this
Yeah, he
auditorium.
was. No, I agree. He was.
He gave you a solid hour of what he really.
Something to think about.
It's opening up and everything.
And it was perfect.
Yeah, let me make sure. This, I'm putting in
More or less, this
Jesse's
is
right
under
now.
control, so it
Okay.
should be.
Yeah, I'll make sure.
So I just got an anecdote from someone speaking on behalf of
I'm glad you got to listen.
sending me her message from God and Jesus.
Hopefully you've got help with the hijack.
Hi, Jessica. I think
Okay, so that.
there's a row of not assigned seats, but just speakers,
We good here?
not on your panel. So you're in front. You're like
Awesome,
I know, right?
awesome,
Yeah.
awesome.
Test.
Sleep on it, I guess.
Yeah. I'm kind of semi-used to it. I get a lot of goofy stuff.
Yeah.
You know, I'm probably from doing like, usually whenever you get quoted in paper or something, it usually gets you at least a couple. If you don't hide your email address, they'll find it.
Oh, yeah. Yeah, it's up there.
Morning.
How are you?
How are you?
Fine, thanks. What do you want?
No, yeah, no, you're waiting till, you're not on till this afternoon.
I understand that.
So there's all these reserved seats for you guys. If there's anyone that's got
You have that list.
I gave it to Jessica.
Okay, I'll let it.
Okay.
Test.